Alice is the head of law and assistant professor in law at New College of the Humanities, and is here today to present her paper, Continuous Wrongs, Privacy Invasions, and Discriminatory Treatment. Alice, you have the floor.
Okay, thank you very much, Andreas, for this introduction, and thanks to the JDG for inviting me to present. So, okay, this paper is sort of my attempt at doing specialist jurisprudence. So specifically to think about two types of wrongs that the law also addresses, which are privacy invasions and discriminatory treatment, and whether they have a relationship and what that relationship might look like. So I think if you've read the paper, you'll know that I'm making roughly two types of arguments about the relationship between privacy and discriminatory treatment, and they respond to sort of big questions I had. And the first question was, should and could legal protections of privacy be used to preempt, to avoid discriminatory treatment? And is preventing discriminatory treatment, is that part of the value or the purpose of privacy? So is that the kind of thing that privacy is supposed to do? What exactly is the relationship between privacy invasions and discriminatory treatment? And I think the first part of my paper is perhaps a little bit more straightforward. So what I say there is I have some conditions in mind that I think ought to be the case for us to be able to rely on privacy, legal protections of privacy to do this job, right? To work as a type of proto-anti-discrimination law. So I think maybe it's fair to say that this isn't, the argument I make there isn't very analytically or conceptually ambitious, right? I treat those as distinctive rights. We might rely on one to get some mileage in terms of the other one. That's roughly the argument. And in the second part, I talk a little bit more about whether there's a closer connection. And I'll get to that soon. So yeah, so in part one, my answer is, can we rely on privacy to prevent or preempt discriminatory treatment? And I basically say, well, it depends, right? I have some conditions in mind. So I'll maybe say some words about how I came to think about this question, because I think it's relevant that this proposition, the notion that privacy is supposed to do this job, supposed to guard against discriminatory treatment, is a proposition that seems to me to be very pervasive. A lot of people more or less casually argue this. And I actually came to this in the context of my DPhil research. So I did my DPhil at the Center for Socio-Legal Studies here at Oxford. And the focus of my research was the sort of social and political factors that compelled different legal systems to afford legal recognition to privacy, recognize privacy as a right. And one of the legal systems I was looking at was Germany, and how Germany developed data protection laws. And in fact, Germany was a bit of a pioneer in that area of law. So the Data Protection Act of the state of Hesse was arguably the first of its kind in the world. And one of the things that struck me in my research was that in the debate, the political discourses that preceded instances where privacy was afforded legal recognition, there was always a lot of talk about the kind of dystopian ways the future government might use information about us, it might use databases. And in the German context, this was clearly motivated by historical experiences with National Socialism, and also a bit by East German experiences with communism and Stasi surveillance, that type of thing. So in fact, in footnote 4 of the paper in my introduction, I have a passage from my research from one of the parliamentary debates preceding the passage of the Federal Data Protection Act in Germany. And in the passage, the concern that is voiced is that, if we register too much information about the population and store this information in databases, it could provide a government with the data that could be used for singling out and presumably disadvantageously treating a certain group, for instance, Jews, clearly alluding to, you know, histories of discriminatory treatment. So I think that's a really interesting concern here, that this is one of the reasons why we need privacy protections, why we need data protections, because spontaneously my thinking was, well, but we have anti-discrimination laws, right? Like even in Germany in the 1970s and 80s, certainly at least public bodies were under the clear legal obligation not to discriminate on the basis of gender and religion and so on. So then why do we need privacy laws to kind of do this work? And this argument didn't actually make it into my DPhil, but it kind of stuck with me. And I became quite sensitized to it. And then it became apparent that this is a proposition that a lot of people make. So one instance where this proposition is made in a really compelling way, I think, is in a paper called The Right to Reasonable Inferences by Sandra Wachter and Brent Mittelstadt from the OII in Oxford. And they argue that we can use data protection laws to prevent against discriminatory, biased decision-making in algorithmic contexts. And so, yeah, anyway, I thought this proposition deserves some critical analytical attention. Now, maybe now's a good time to point out a disclaimer, or to make a disclaimer. So when I talk about discrimination or discriminatory treatment, I use it in a moralized sense. So I assume that it's morally wrong to treat people disadvantageously on the basis of certain characteristics like race or gender. And when I talk about privacy, I generally mean information privacy. So some people use privacy more broadly to encompass things like decisional privacy, for example, or just generically being left alone by the state. But I mean information privacy, and I use that sort of interchangeably with data protection. Now, you might argue data protection is broader than just privacy. Maybe it's supposed to be about more things than privacy. And I think that's right. Maybe we can talk about that, you know, in the Q&A. But so far, that's just roughly the way I use the terminology. Also, in this paper, I really only talk about direct discrimination, so not about indirect discrimination. And I think if we think about continuities between privacy invasions and indirect discrimination, there may be some really interesting and quite different things there to be said, to be ascertained. So it's a question I'm certainly thinking about, but it seemed maybe a little bit too much to package into one paper. So yeah. So before I get to the conditions that I have in mind that play a role in, you know, when I think we might be able to use on privacy norms to preempt discriminatory treatment, I talk a little bit in part one about what discriminatory treatment actually is. What does it mean to discriminate? And I draw on the work of various people who've discussed discriminatory treatment, arriving roughly at the description that to discriminate is to afford unfavorable or less favorable or disadvantageous treatment to a person or persons on the ground of a particular reason that relates to a person's membership of a socially salient group. I think the person who emphasized that we can describe this characteristic, right, say a person's race or a person's gender, as a reason, that this is the reason for why a person is treated disadvantageously, was John Gardner. So I think it's really interesting to think of these characteristics in terms of reasons that they feature as reasons for certain kinds of actions. In our case, disadvantageous treatment is the action. If we think about discrimination in this way, I think it's quite clear, quite immediately obvious why so many people suggest that perhaps privacy norms can do some work here to prevent this kind of treatment. Because, you know, if anti-discrimination laws are about excluding these considerations from the way people act, then we might think yeah, but what about unconscious biases, right? I mean, a lot of the time people might not be fully aware that characteristics like gender or race are a motivating factor in the way that they treat others. So just expressing an outright prohibition, which anti-discrimination laws do, might not go very far in terms of addressing that concern. So maybe it would be better for people just not to know the relevant information about, say, a person's race or a person's gender in the first place. And I think this is where the idea to rely on privacy kind of comes in. Okay, so moving to my 4 conditions. The conditions I outline in this paper, I should say, I think these conditions are probably a bit fuzzy at the edges and they kind of overlap a bit. But yeah, this is just what struck me as relevant. So I think the first few ones are perhaps kind of obvious, and then later it gets maybe a little bit more tricky. But the first condition is the kind of information protected under privacy norms must include information relating to membership of a protected group. So a term that is often used to describe those groups that have contingently historically faced disadvantageous treatment is to describe those groups as socially salient. I've talked in my paper a little bit about what people have in mind there, but just so that you're not confused in case you haven't read the paper, socially salient means this is a group of people defined by certain characteristics, and this group of people has historically been subject to relevant, pervasive, and significant disadvantage. So, okay, so the fact that a person is a member of such a group, that person, for instance, is a member of, you know, the group of women, must be included under privacy laws. So privacy norms must protect this type of information for us to be able to rely on privacy norms in the first place. That's kind of obvious. And there are examples of this being the case. I mean, oftentimes information pertaining to our gender, you know, our race, our age, maybe our sexual orientation is quite explicitly protected by privacy norms. And Article 9 of the GDPR is an example here. But the problem is that a lot of contexts that are particularly at risk of discriminatory treatment, like practically all types of face-to-face interactions, are such that relevant characteristics probably couldn't be hidden, right? If I see a person walking down the street, their gender and race will oftentimes, though not always, be quite obvious. So in those types of situations, usually the law wouldn't recognize that there is a reasonable expectation to protect relevant information under privacy norms, just because it's so easily visible and perceptible. So in those ways, I think privacy norms track a little bit of what can reasonably be expected of people, right? So I can't reasonably expect that people don't notice, you know, my gender or my race if it's so obvious when they talk to me. So that's a big problem. I talk a little bit about the fact that a lot of our social interactions, at least these days, happen online. So there is a certain way in which mediated social interactions might change that and might make it more feasible to hide relevant information in various types of contexts, although probably not on Zoom. But then on the other hand, you know, online data collection practices mean that more and different kinds of information can be collected about our behavior online, much more information than in face-to-face interactions. So, you know, relying on privacy to do this work, we might have different ideas about the extent to which that's possible. So social realities play a significant role in the extent to which privacy might be able to do this work. This sort of plays into my thinking about condition 2. So in condition 2, I say that in the relevant social scenario, it must be practically feasible to keep the information relating to our socially salient group membership hidden. And this, of course, picks up on many social scenarios where that isn't practically feasible, but it also relates to scenarios where we might say, yeah, it's theoretically possible, but it would be extremely onerous. Like it would, to hide, say, the fact that I am female would require like me dressing up in weird ways. It's theoretically possible, but it would be so onerous that it can't plausibly be expected of me. So I think, yeah, this is also what I also say in terms of this characteristic or this condition, is that the perceptibility of information relating to our various socially salient group memberships is probably on a spectrum, right? So some things are easily perceptible and some not so much. But in order for us to be able to rely on privacy norms to preempt discriminatory treatment, it must be entirely possible to hide the relevant information. If it's just possible to hide it a little bit and it still can be seen a little bit, then of course that undermines the whole purpose. Then in condition 3, I talk about the fact that I think another condition is that keeping relevant information hidden must not confer an undue burden or added disadvantage onto those at risk of discrimination. So perhaps there's a continuity in terms of situations where it's extremely onerous to hide relevant information. But there are also some additional examples. So for instance, I talk quite a bit about the fact that relying on privacy might insinuate, might suggest that those people at risk of discriminatory treatment have an obligation to hide their relevant group membership and thus foster implications that say, particularly in the context of sexual orientation, that being homosexual is somehow shameful or deviant, right? If this is something you're supposed to hide. And there's a certain risk there. Now we might say, well, that's just a misunderstanding of what privacy is all about. To say that something should be kept private isn't to imply that it's shameful. But if that is practically the conclusion, even if it's an incorrect conclusion, if that's practically the conclusion that people draw, then that's risky. Yeah. In practice, privacy protections often come with a stigma. So another instance in which concealing information about a protected status would create a disadvantage for those at risk of discrimination, I say, is when supplying information about one's identity is an advantage. And an example I give here is like, say, a dating app, right? And on dating apps, we know it's quite common that people who are, or women who are Black tend to be less successful at attracting, interested potential partners. And so, if the conclusion is, or if the approach is to tell women who are Black to hide their racial identity and not share information, this might backfire, both in the sense that people who are white and who do share the information that they are white, might still have an advantage over those who are Black and on this dating app. And also, just not supplying a lot of information about you might mean that other people on this dating app are less interested in you, right? So, for instance, not uploading pictures might mean other people are less likely to, say, match with you. So I'm not sure this is a great example. I just couldn't think of a different type of example, I think, in this context. But I think there are examples where providing information, there's an incentive to provide information. Providing information gives you certain types of benefits. And if you don't do that because you rely on privacy to hide group membership related information, that might put you at a disadvantage. Another concern is, of course, hiding information in contexts where you kind of need to supply information for people to make reasonable adjustments. For instance, if this concerns a disability, And a related concern is affirmative action, right? Where you need to supply information about your membership of certain groups in order to benefit from various types of reasonable adjustments, existing schemes. This, I think, I discussed this in the following condition, in my condition 4, because I think that I'm not sure that missing out on affirmative action quite qualifies as an undue burden or added disadvantage, right? A disadvantage that you incur in addition to being at risk of discriminatory treatment. So I think I basically put it into the next condition. So condition 4 is the one that I think is a bit controversial. Here I say that another condition for us to rely on privacy norms to preempt from discriminatory treatment is that it must not undermine systemic efforts to address existing social inequalities. Now, you might say, well, why is this controversial? I mean, surely if relying on privacy norms, has that effect, then that's obviously disadvantageous. So, why is this controversial? It's perhaps controversial because I'm trying to say a little bit more than that. I'm saying it's not just a downside, but it's counterproductive to the purpose of anti-discrimination. So it undermines what anti-discrimination laws are all about. And in order to be able to say that, I have to make the argument that anti-discrimination laws are effectively about addressing existing social injustices or anti-discrimination norms. The notion that anti-discrimination is wrongful has to do with the fact that our society is structured in certain socially unequal ways, and that's a problem. And discrimination perpetuates that, and we ought to address it to change social realities. So not everyone might agree with this, right? Not everyone might agree that there's a broader kind of social engineering purpose to anti-discrimination laws. You might say, no, it's just about reducing particular instances of discriminatory treatment. It's not about affecting social justice. So in this section, I talk a little bit about what it is that makes discrimination wrong. And people have different accounts. I think a lot of accounts are quite compelling. I think the most compelling accounts would have to explain what makes discriminatory treatment on the basis of group membership, so for instance, a person's race, worse than disadvantageous treatment that's idiosyncratic, right? So not getting a job because, say, you're a Capricorn. And the thing is that this is something that I think in the literature, there's if you have the view that one just isn't worse than the other, that not getting the job because you're a woman is just as bad as not getting the job because you're a Capricorn, it's not entirely clear what we might say to convince such a person. But I have some things in mind that I think can be said here, but at least in the literature, it seems that, well, it's already most people's intuition that there is something morally relevant about incurring disadvantageous treatment on the basis of group membership, rather than idiosyncratic, unfair treatment. So the presumption is that this is relevant. Now, if we say this is relevant, group membership is relevant, then we have to ask, well, why? What is it about these groups? And then, of course, we get into discussing, social, historical, very much contingent legacies of disadvantageous and unequal treatment. And we have to say that we get some genealogical moral import out of that, right? That the fact that those groups have been treated in relevant ways makes it so that treating somebody disadvantageously on the basis of group membership is particularly bad. Okay, so this is then I talk about ways in which under condition for ways in which relying on privacy norms might have this effect of undermining systemic efforts to address existing injustices. I think the two main things that I think are convincing here is one, of course, affirmative action, where you actually need to know this type of information to engage in active efforts to address existing injustices, and also for us to gather information about the injustices that kind of exist. We can't shield that through privacy norms. That's a big kind of long-standing feminist critique of privacy, that privacy norms, not just privacy laws, but also the norms of just keeping certain types of information private, has sort of played into not recognizing structures of gender expression in domestic contexts. So though this is a way in which relying on privacy norms might be counterproductive, I claim, to the whole enterprise of anti-discrimination, the whole moral legal enterprise. Okay, I just have a few minutes left, moving to section 2 of my argument. So section 2, I think, is fair to say, is kind of some thoughts I have, some preliminary thoughts I have about the relationship, about how we could describe the relationship between privacy invasions and discriminatory treatment, whether we can say something more kind of conceptually interesting, then sometimes we cannot rely on one to get some purchase out of the other. So here I say, what depends a lot on how you define privacy. Different people have different understandings of privacy. Privacy is one of those concepts where it seems really hard to get people to agree. So I identify, I think, let's go to the slide. Yeah, sorry, I've just moved to the slides. Yeah, so in part 2, I talk about analogies from discriminatory treatment. And I say, depending on what understanding you have of what privacy is about, right? So if you take an expansive view, what privacy entails, a reductive view, what privacy entails, if you think that privacy violations are ultimately about violating some underlying value, then that might have implications for what you think the relationship between privacy invasions and discriminatory treatments are. Now, I don't really want to adopt any of those views. I don't want to adopt the expansive view where I think that, treating people discriminatorily on the basis of private information is part of a privacy invasion, where I have a really expansive understanding of what a privacy invasion entails, right? So additional harms on this view, I would say, are not epiphenomenal, but they are part of the privacy invasion. Some people seem to be saying that. I don't want to say that. I also don't want to adopt the reductive view where people say, and one good example is Judith Jarvis Thompson, where people say, well, I think privacy interests can really be reduced to interests that are ultimately about other things. I don't want to say that either. I think there is something distinctive and coherent about privacy. Third value views, I think, are interesting, where you say, well, to violate privacy is ultimately to violate, say, autonomy or dignity. And maybe we can make a similar claim when it comes to discriminatory treatment, that perhaps a similar third value underpins both privacy violations and discriminatory treatment. I have been thinking about that quite a lot, but I haven't put my thinking about that in this paper. So I, for now, just kind of remain agnostic about that. So what I want to say in this paper is, something perhaps less ontologically ambitious. I think all I want to say for now is that privacy invasions and discriminatory treatment can really be understood analogously. And I argue this in 2 sections. In the first section, I say that while discriminatory treatment is treating others disadvantageously on the basis of illicit reasons for action, and privacy invasions are states of knowledge about others on the basis of illicit reasons for belief. Now, that poses a few problems. The first problem is, what about machines or information systems that collect data about us? We also often want to call that privacy invasions. I'm a little bit skeptical about that. I think, there's something distinctive about other people knowing things about us that makes them privacy invasions. And the second problem is, well, can knowing something about another person be wrongful, right? Isn't that like kind of suggesting that knowing something is a thought crime? I talk about that quite a bit in this paper. I talk about the fact that it might still be reasonable for the law to say it is the actions that bring about this knowledge that we target, right? Pragmatically in terms of our legal choices. But it strikes me that yes, other people's knowledge about us can constitute harm. That's, I think, an idea that's certainly not very strange to the literature about discrimination. The notion that, having prejudices is something that can constitute a harm even without anyone engaging in any further disadvantageous activity. I realize I'm nearly out of time. Very briefly, what I think on the second part of part 2, I talk about what I think constitutes a certain continuity between privacy invasions and discriminatory treatment. And specifically, I think, while there's a certain continuity between the kind of illicit reasons that are used in discrimination and that are used as a basis for our states of knowledge about others. Specifically, those types of reasons, I say, relate to the ways in which we're socially vulnerable, the contingent ways in which in our societies we're socially vulnerable. And the literature on discrimination does a pretty good job of outlining how group membership makes us socially vulnerable, how the fact that in this particular society, we are female, for instance, or we are disabled, how that makes us vulnerable to the views and treatment of others. And what I say is that in the case of privacy invasions, when we recognize that some kind of information about us ought to be protected by privacy, so ought to fall into the notion of a reasonable expectation of privacy or as belonging to the private sphere, oftentimes, or I think in general, our rationale, the underlying rationale for that is that we think, yes, this type of information also makes us socially vulnerable in a certain kind of way. Perhaps sometimes in the ways that being a member of a particular socially salient group makes us socially vulnerable, but sometimes also in ways that are more specific and more ephemeral, right? So for instance, just the state of being naked or the state of being very emotional, being overwhelmed by strong emotions is something that makes us socially vulnerable to the views and the treatment of others. So those are information about those states is what we might say ought to belong to the private realm, ought to be protected by privacy as a norm. Okay, I don't want to take up too much time. That's really all that I have to say about this paper. I'm really interested to hear what you think. It strikes me that a lot of what I say in part 2 isn't developed in a lot of detail, but I thought maybe it's worth still presenting it, in a case where I'm still developing those thoughts, because then this discussion group can be used to develop my thinking rather than just to defend it. So yeah, very interested to hear what you're thinking.